A very good afternoon to all of you. I'm Pratyush Kumar from National Law University, Delhi, speaking on module Geographical Indications. First of all, the introduction. What is the definition and meaning of geographical indication? A geographical indication is a sign used on goods that have a specific geographical origin and possess qualities, reputation or characteristics that are essentially attributable to that place of origin. So essentially, any sign which indicates that a certain product originated from a particular place, and when that product has any quality attributable, such indication is called a geographical indication. Before we see some examples, it is essential that we consider two other terms, appellations of origin and indications of source. Indications of source. It is pertinent to state that the term has not been defined in any of the international treaties, though the term has been used in the Paris Convention. An example of an appellation of origin is champagne, which is used to indicate that a special kind of sparkling wine originating in the Champagne region of France. In India, Section 2(1)(g) of the Geographical Indications of Goods, Registration and Protection Act 1999 defines geographical indication in relation to goods to mean an indication which identifies such goods as agricultural goods, natural goods, or manufactured goods as originating or manufactured in the territory of a country or a region or locality in that territory where a given quality, reputation, or other characteristic of such goods is essentially attributable to its geographical origin, and in case where such goods are manufactured goods, one of the activities of either the production or of processing or preparation of the goods concerned takes place in such territory, region or locality as the case may be. For the purposes of this clause, any name which is not the name of a country, region or locality of that country shall also be considered as the geographical indication if it relates to a specific geographical area and is used upon or in relation to particular goods originating from that country, region or locality as the case may be. In other words, geographical indications are indications in any form used to identify a source of origination of a product, be it a naturally grown one or a manufactured one. They are primarily used for promotions by intimating the consumers of the source of a particular product. Now we will see the interlinkages between geographical indication and trademarks. The difference between trademarks and geographical indications is pretty simple. But before we embark on that, let us discuss a few similarities between trademarks and geographical indications. At a first point of contact with which everyone is familiar is that both are distinctive symbols. Another point of contact stems from the foregoing, that is, both differentiate some products from others. However, trademarks differentiate the products made by different producers, and geographical indications differentiate one group of products from others and don't come from the region it protects. This property of a geographical indication makes it a collective mark. Another difference is that trademarks arise from the creative genius of man, while geographical indications are not created. They are there in nature due to the existence of human and natural factors. The third difference between them is that, unlike the case of trademark, social recognition must already be recognized before the idea and need for their protection arise. Geographical indications protection under TRIPS. Definition: a geographical indication identifies goods that originate from a particular place where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. Provisions against misleading the public. Member states are required to provide the mechanisms that enable interested parties to prevent untruthful and misleading uses of geographical indications. In other words, tea growers in Nepal may not call their tea Darjeeling or Kangra, even if they are genetically identical to tea grown in Darjeeling or Kangra. In addition, literal truth is not a defense if the use of the geographical indication misleads the public. Therefore, tea growers in Darjeeling, which is a place somewhere else than the Darjeeling in West Bengal, India, may not market their tea as Darjeeling tea. Member states whose legislation would otherwise permit this use must refuse to register or cancel registrations of misleading geographical indications. Indian legislation, the GI Act 1999, provides exactly for this. Additional protection for geographical indications for wines and spirits. Article 23. Articles 23 and 24 provide broader protection for geographical indications for wines and spirits than for other products. An interested party need not prove that the public has been misled by the use of the indication in order to obtain relief. Even if the public is not misled by an advertisement for Saint Emilion style Bordeaux, imitation Calvados, or New St. George's quality wine, such a use violates Article 23. A grandfather clause, however, permits continuing uses of indications initiated more than 10 years preceding the end of the Uruguay round, or any good faith use initiated before that date. In addition, until a geographical indication is protected in its country of origin, rights acquired in good faith through use or registration of a trademark incorporating the indication are immune from attack. The additional protection for both wines and spirits includes three elements: the provision of the legal means for interested parties to prevent the use of a geographical indication identifying wines and spirits not originating in the place indicated by the geographical indication; the possibility to refuse or invalidate the registration of a trademark for wines or spirits which contains or consists of a geographical indication identifying wines or spirits at the request of an interested party; and last, the call for future negotiations aimed at increasing protection for individual geographical indications for wines and spirits. An extra additional protection by the TRIPS agreement for wines only emphasizes the need to accord protection for each geographical indication for wines in the case of homonymous indications and the establishment of a multilateral system of notification and registration of geographical indications for wines eligible for protection in the jurisdictions of those WTO members participating in the system. To emphasize the lack of protection for generic geographic indications, Article 24 expressly preserves the right to use geographical indications that are identical with the term customary in common language as the common name for such goods. Burgundy, Rhine, and Chablis for wine would seem to fall into this category within the borders of the United States, as certainly would Champagne. Although the French have worked hard to deter the generic use of champagne on naturally carbonated sparkling white wine beverages that do not originate in the region surrounding Reims, France, they have failed in the United States to influence the common language, in which champagne is the common name for sparkling wine rather than a source indicator. Arguments against protection would not apply, however, in countries where consumers expect that all Burgundy and Champagne come from France. Exceptions. Article 24. In some cases, geographical indications do not have to be protected, or the protection can be limited. Among the exceptions that the agreement allows are when a name has become the common or generic term, for example, cheddar, now refers to a particular type of cheese not necessarily made in cheddar in the UK, and when a term has already been registered as a trademark. Countries employ a wide variety of legal means to protect geographical indications, ranging from specific geographical indications laws to trademark law, consumer protection law, and common law. The TRIPS agreement and current TRIPS work in the WTO keeps track of that diversity. The Doha Mandate. Two issues are debated under the Doha Mandate, both related in different ways to the higher Article 23 level of protection, creating a multilateral register for wines and spirits, and extending the higher Article 23 level of protection beyond wines and spirits. The multilateral register for wines and spirits. This negotiation, which takes place in dedicated special sessions of the TRIPS Council, is about creating a multilateral system for notifying and registering geographical indications for wines and spirits. These are given a level of protection that is higher than for other geographical indications as explained above. Latest development in this arena is to be found in the report of the Trade Negotiations Committee by current chairperson Darlington Mwape of Zambia. 3 sets of proposals have been submitted over the years, representing the 2 main lines of argument in the negotiations and some proposed compromises. The EU's detailed proposal calls for the TRIPS agreement to be amended by adding an annexure to Article 23(4). The paper proposes that when a geographical indication is registered, this would establish a rebuttable presumption that the term is to be protected in other WTO members, except in a country that has lodged a reservation within a specified period, for example 18 months. A reservation would have to be on permitted grounds. These include when a term has become generic or when it does not fit the definition of a geographical indication. If it does not make a reservation, a country would not be able to refuse protection on these grounds after the term has been registered. A joint proposal document was first submitted in 2005 and revised in 2008. Its sponsors are Argentina, Australia, Canada, Chile, Costa Rica, Dominican Republic, Ecuador, El Salvador, Guatemala, and so on, including the United States. This group does not want to amend the TRIPS agreement. Instead, it proposes a decision by the TRIPS Council to set up a voluntary system where notified geographical indications would be registered in a database. Those governments choosing to participate in the system would have to consult the database when taking decisions on protection in their own countries. Non-participating members would be encouraged but not obliged to consult the database. Hong Kong, China has proposed a compromise. Here, a registered term would enjoy a more limited presumption than under the EU proposal, and only in those countries choosing to participate in the system. At the heart of the debate are a number of key questions. When a geographical indication is registered in the system, what legal effect, if any, would that need to have within member countries? If the register is to serve the purpose of facilitating protection, the phrase used in Article 23.4, and to what extent, if at all, should the effect apply to countries choosing not to participate in the system. There is also the question of the administrative and financial costs for individual governments and whether they would outweigh the possible benefits. Extending the higher level of protection beyond wines and spirits. Geographical indications for all products are currently covered by Article 22 of the TRIPS agreement. The issue here is whether to expand the higher level of protection currently given to wines and spirits to other products. A number of countries want to negotiate extending this higher level of protection to other products. Some others oppose the move, and the debate has included the question of whether the Doha Declaration provides a mandate for negotiations. Some countries have said that progress in this aspect of geographical indications would make it easier for them to agree to a significant deal in agriculture. Others reject the view that the Doha Declaration makes this part of the balance of the negotiations. This difference of opinion over the mandates means that the discussions have had to be organized carefully. At first, they continued in the TRIPS Council. More recently, they have been the subject of informal consultations chaired by the WTO Director General or by one of his deputies. Members remain deeply divided with no agreement in sight, although they are ready to continue discussing the issue. Requirement of registration. Under the Indian Act, no protection is conferred on an unregistered GI. Consequently, the proprietor of an unregistered GI has no remedy against an infringement of his mark. So we can conclude registration of a GI is mandatory under the Indian Act, but passing off action by an original proprietor of a mark has not been barred under the Act. The relevant provision reads, "Nothing in this Act shall be deemed to affect rights of action against any person for passing off goods as the goods of another person or the remedies in respect thereof." Some case studies. Tirupati Laddu controversies. A PIL was filed before the Madras High Court against the GI tag for the Tirupati Laddu. That petition was dismissed on the grounds that an alternative and efficacious forum was available for adjudication of such a dispute, and hence the PIL was dismissed with directions to the petitioner to approach the appropriate forum. Under the GI Act, such a petition could have been filed either before the GI registry or the IPAB. R.S. Praveen Raj, a resident of Thiruvananthapuram and a scientist at NIIST, National Institute for Interdisciplinary Science and Technology, made a plea against GI tag of Tirupati Laddu. The petition raised certain issues fundamental to the nature of GI protection as violation of section 11.1 read with rules 32.5 and 32.6 A and F, as GIs are supposed to be collective community rights of protecting a group of producers. In the present case, TTD is the sole producer and beneficiary of the laddu. Violation of sections 9A and D, as the registration is likely to deceive consumers. Section 9A and is likely to hurt religious susceptibilities of communities in India. Section 9D. Tirupati Laddu does not fit the description of goods defined under section 2F for it being a sacred offering not akin to industrial goods. An executive officer of TTD argued that rectification application had no locus standi. The officer also made it clear that the rectification applicant was not offended in any way by the registration, and he had never objected when the matter was published in the Geographical Indications Journal. He further said that all procedural formalities contemplated under the prescribed Act and rules was strictly adhered to, and genuineness of the product was verified by the experts. The Geographical Indications Registry, Chennai, rejected the plea by the applicant for removal of GI tag against Tirupati Laddu. Rectification applicant R.S. Praveen Raj failed to prove locus standi and interest with the registered good. The court stated that because the rectification application was not contested by the applicant, the tribunal is empowered with the authority to impose costs. Jamnagar Petrol. Reliance Industries Limited had filed a GI application for its Krishna Godavari gas and Jamnagar petrol, diesel and LPG. The application sought authorized usage of the name Jamnagar LPG, oil, petrol and diesel. Though later the application was abandoned by Reliance, but the specification and the rationale behind its acceptance are worth wondering at. Section 11(2) of the GI Act mandates an application to contain a statement that proves or establishes the GI to designate the goods as originating from the concerned region in respect of specific quality, reputation and other characteristics of which are due exclusively or essentially to the geographical environment with its inherent natural and human factors. Under specification, RIL stated that the ISO standards met by its petrol, fuel, LPG and diesel. There was no mention of any unique properties possessed by the goods. There was no mention of any unique properties possessed by the goods in the application by RIL except the compliance with ISO standards. Under the column Proof of Origin, Historical Records, Reliance stated as follows. In 1991, the Government of India allowed the investments from the private sector in this field. Heavy investment has been made in the less favored remote area, which has resulted in the improvement of local rural area and paved way for the retention of the rural population in this area, and it helps in the rural development. The applicant, in a record time of 15 days after the historic heavy cyclonic hit on 8 June 1998, repaired the extensive damage and brought back the normalcy. The whole matter was dubious, and the surprising fact was how the registry had allowed such a publication. The controversy was more or less ended after Reliance abandoned the application. Basmati rice. On 2nd September 1997, the US had granted patent number 5663484 to Rice Tech Incorporation, a US multinational company, for new lines and grains in the name of Basmati rice. This was objected to by two Indian non-governmental organizations, Center for Food Safety, an international NGO that campaigns against biopiracy, and the Research Foundation for Science, Technology and Ecology, an Indian environmental NGO who filed legal petitions in the United States. The Center for Scientific and Industrial Research also objected to it. They sought trade protection for Basmati rice of the Indian subcontinent and jasmine rice of Thailand. They demanded amendment of US rice standards to specify that the term Basmati can be used only for rice grown in India and Pakistan, and jasmine for the Thai rice. The Indian government, after putting together the evidence, officially challenged the patent in June 2000. The contention of Rice Tech was that Basmati is not a name of a geographical area, and hence it is not qualified for protection under the TRIPS agreement. However, when it was proved that though the name Basmati is not the name of a geographical area, but still it is inextricably linked to its region of origin, that is India, Rice Tech contended that Basmati is a generic name and has fallen into the public domain. In 2000, after years of litigation and hearing, the USPTO granted patent only to a few varieties instead of the sweeping claim of new lines and grains. But the event was an eye-opener for India, and it was in this backdrop that the GI Act of India was passed in 1999. Darjeeling Tea Board, a statutory authority of the Government of India established in 1953 under the Tea Act 1953 for the purpose of controlling Indian tea industry, owns the GI for Darjeeling tea, which is the tea grown in 87 gardens in the district of Darjeeling. The Tea Board has fought more than 15 cases against infringement and misuse of Darjeeling in the last 4 years, including Sri Lanka, where the importer agreed to abide by the regulations. This is an effort that stems beyond areas where Darjeeling tea is exported. Republic of Tea, USA, 2000 to 2006. Tea Board was successful in seeking rejection of trademark application for Darjeeling Nouveau in the name of Republic of Tea on the basis of its geographical certification marks for Darjeeling word and logo. The opposition had been filed by the Tea Board before the Trademark Trial and Appeal Board, which has not only upheld Tea Board's opposition but also denied Republic of Tea's counterclaim for cancellation of the Darjeeling certification mark on grounds of genericness. The Trademark Trial and Appeal Board held that Republic of Tea had not proved that consumers view Darjeeling tea as a generic type as opposed to tea from the Darjeeling region of India. It also recognized Tea Board's continuing efforts to maintain control of the mark and protect its value as a geographic indication. The Trademark Trial and Appeal Board held that regulations and licensing program put in place by the Tea Board constitute adequate provisions for control. It also placed great stock in the Tea Board's ongoing efforts to educate the public, example by attending trade shows and distributing literature in supermarkets as further evidence of the Tea Board's overall system of controlling consumer understanding. Dusong, Darjeeling with kettle device for stationery, France. The Court of Appeal of Paris on November 22, 2006 quashed the decision of the Court of First Instance rendered in August 2005, wherein the action filed by the Tea Board for dilution of Darjeeling against adoption of the mark Darjeeling with a kettle device in respect of classes 16, 35 and 41 by Mr. Dusong. In its decision, the Court of Appeal Paris held that Mr. Dusong's mark impairs the geographical indication Darjeeling and is prejudicial to the Tea Board's interests in the same. Accordingly, the impugned mark was nullified. Mr. Dusong has been restrained from using the same in any connection whatsoever. Further, the court has imposed a fine of Euros 500 for each breach that would occur after 1 month of notification of the decision. Mr. Dusong was to publish at his expense, but within a total of Euros 5,000, the decision in 3 newspapers, either French or foreign, of Tea Board's choice. Mr. Dusong was also sentenced by the court to pay an amount of Euros 2,000 to the Tea Board. Other cases. Other marks opposed including Divine Darjeeling, Darjeeling Nouveau, relating to diverse goods and services such as clothing, lingerie, telecommunication and internet services, coffee, cocoa, etc. Further used by BVLGARI Switzerland of the legend Darjeeling tea fragrance for men was agreed to be withdrawn pursuant to legal notice and notifications. To conclude, I would like to discuss the EU-India FTA. The Free Trade Agreement, or FTA, was to be entered into by the European Commission to regulate issues such as competition policy, the rights of foreign investors, open government purchasing practices, as well as environmental, social and human rights clauses. However, sharp differences arose with respect to intellectual property rights, competition, agriculture, public procurement, market access and transparency. One relevant example was the concern raised by Amul in 2013. It was feared that further reduction in import duties would enable the EU to dump subsidized products in the Indian market, as EU did not allow import of Indian dairy products, citing its strict sanitary standards, which is suspected to be nothing but a non-tariff barrier. Thank you and a very good afternoon to all of you.